Okay, well, I think Chuck just needed a break because he brings a lot of energy to his presentation. So I'll try to match his energy. And I do want to thank Kate because she did put this together. And she does a lot of the public records work for the district. So Holly back here is your public records clerk. Everybody should get to know her. If you have a question about a public record request, it should funnel through Holly and then potentially come to our office for evaluation, but she's your first stop. So be familiar with her. The Public Records Act is an old statute. It was adopted in the early 70s. And the purpose is for free and open examination of public records. Washington State has one of the most transparent government requirements in the United States. I have to confess, I came from Virginia. That's where I grew up. We do not have such transparent government. And so a lot of really good things about this, a lot of really annoying things about it when you're a member of a public body. But every member of the public has the right to free and open examination of public records. And I'm going to use my notes because I haven't been practicing quite as long as Chuck. Maybe in a couple of years, I won't have notes with me. But public records of government agencies are presumed open, right? So if you have a question about whether a record is subject to the Public Records Act or exempt, your starting point is it's a public record that's going to be disclosed, right? It's very liberally construed in favor of disclosure. The courts have been very, very clear about this. They want public bodies to disclose records. They have analyzed the statute for almost 50 years now, and they almost always come down on the side of disclosure. There have been some recent cases that have come out where the courts have invited the legislature to put some limits on the Public Records Act, but the legislature has not chosen to do so. And we'll talk about that a little bit. Every agency is required to have procedures in place to process public records. That's what Holly does, right? We have a specific procedure here in the district to process public records requests. So if you get a public records request that comes to you in your capacity as a board member, make sure you are forwarding that on to Holly so that we can process it through the correct channel. And then importantly, unless a specific exemption applies to the record, you've got to disclose it. And there aren't that many exemptions, frankly. There are some specific exemptions to protect the privacy of individuals. There are going to be specific exemptions that apply to some of the records that the health district holds because they may have what's called PHI or health identifying information. Certain medical records aren't subject to disclosure. Other things like some school records aren't subject to disclosure. Most employment records are subject to disclosure, but there's some exceptions, right? If there's an ongoing investigation, that ongoing investigation is not subject to disclosure until it's final. But once it's final and you have a report, that report goes out. And that it gets disclosed. There's no exemption. Now, that's not to say that when you release a record that it can't be redacted in some way, right? There's some individual information that can be redacted from a public record, even if the record is not exempt, right? And the specific example that I deal with a lot, because my main area of practice is in the employment and labor sphere, is when I do an investigation for a public agency, the names that appear in that final investigatory report, those are redacted unless you have specific permission from the employee to send it out. Well, and one more thing on exemption versus redaction, sorry. If you have a question about it or you're unsure, send it to Holly, send it to us, right? Don't make a decision, don't make an assumption that something's exempt because you read it in the statute. make sure it goes through our appropriate process. Okay, so who does the Public Records Act apply to? State and local agencies. So the health district is a local agency because it includes cities, towns, municipal corporations, special purpose districts. What is a public record? Don't get hung up on that second word because that's not how it's interpreted. But the definition in the statute is any writing containing information relating to the conduct of government or the performance of any governmental or proprietary function that's either prepared, owned, used, or retained by the agency, regardless of physical form. So if you accept a record as a member of the board, if somebody comes to you and hands you a document and you accept it in your official capacity, and it has to do with the performance of government function or relates to the conduct of government, you have created a public record by accepting that document. So I want to point that out. I also want to point out writing. Even though it says any writing, that's not really what it means. Public record can be a recording, right? That's considered a writing under the statute. So it's a very, very, very broad definition. If you have a question about whether something you're holding is a public record or not, one, assume that it may be and get in touch with Holly, get in touch with your attorney.
Erin?
Yeah.
What about someone who leaves a voicemail?
That's a public record because we'll go to the next slide. They can include sound and video recording. So if you have a voicemail on your, particularly for you, Mayor Crawford, on your official phone that is relating to government conduct, that would be a potential public record. And if there's a question about it, you should seek counsel, either through your public records officer or your legal counsel.
One of the best ways to leave a message for somebody is
call me back.
Call me back. Right?
Call me back.
Call me back.
Yeah.
Not about anything, just call me back.
Yeah.
So for the health district, do we have a mechanism of archiving those voicemails? And
yes, we do.
Okay.
We currently have the ability to do that. Randy and I have been working on that. Many of you will notice that if you try to call me, I don't have any space in my voicemail. I'm in the process of making sure that I archive the ones that I currently have. And so, but the best remedy for that is just to text, call me or whatever, and then I'll make sure to get back to you. So we're going through the process right now. Our local health system archives everything. Our cell phones and stuff we do the modernization. We're still working on the process to make sure all that is archived.
And we are too. So I was just curious. So we're trying to figure out our best route to do that. So I'm just curious if we have something like that.
Yeah.
Okay.
Yeah.
Dan Sutton had his hand.
Oh.
Go ahead, Dan.
Would you go into some detail so they understand what a public record request might look like? Because it can be very benign and very subtle, and it's actually an official public records request.
Yeah, we're going to talk about that. And here it's a good time to do it right now. So a public records request can come through your formal process, right? Where someone goes to the website, fills out the form, sends it to Holly, and we've got it, and it goes through our process, and it's great, right? But a requester doesn't have to follow that specific process or even use your specific form. If you get an email that may be talking about a lot of different topics and then says, I want to see what the board created on this, or I want to see what the district wrote about this thing. Even though they're not saying, I would like this specific document, that may be a public records request. And so forwarding it to Holly so we can get out a 5-day notice and evaluate if a record exists that we can send is really, really important. So if there is any kind of vague reference to any particular document, reporting, photo, email, text, tweet, comment on social media, that they want that information, if it's anything to do with any information that relates to a government function, then you want to forward it to Holly. It's err on the side of caution and not assuming that it's not a public records request. And we will talk about why you want to do that a little bit later. But when I say, well, yeah, I want to go back to writing, because writings are everything. It can be a photo that doesn't have a word on it, right? But a photo has what's called metadata behind it, which is a writing. It says when the photo was taken, how it was taken, those things are writing. It also has a communication. A photo may be of Kate and I talking about something. Even though that's not a written word, you can see it's a communication because we're communicating something in the photo that we're talking, right? Web pages and sound and video recording. So this recording today is a public record. If someone requests it, it'll go out. Yeah.
How specific are the response times on requests for information?
Yeah. Well, the really important one is the 5-day notice, right? When we get a public record in, we need to have a response out to the requester within 5 business days that says, we have received this, we're looking at it, we're evaluating it, and here's the estimated amount of time that we think will take to respond to your request. If it's a really easy request, right, I would like the board agenda for the May 2021 meeting, right? Holly's probably going to get that. She's going to say, thank you for requesting it. This is your 5-day notice. Here's the record you requested. We are done with your request. Please go and have a lovely life. But if it's something more like, I would like to see all emails between Luke Davies and the public health officer for the entire COVID pandemic. Holly's response is going to be, thank you for requesting this document. This is your 5-day notice. We anticipate it's going to take X amount of time to respond to your request. You will hear from us by then. And then Holly will respond within that time period, either by providing all documents or saying, here's the first batch, we need some additional time, here's the next estimate.
So the 5 days is really just an acknowledgement of the request.
Yes, yeah. Though I do, if it's a very simple request, I do not recommend not providing that document because things happen, right? You get busy, you forget about things. If it's an easy one, you get it out the door, right? And you always, and Holly knows this, want to send a closing letter when you've completed the request, right? That we, here are the documents you requested. We believe this fully responds to you. We are closing this request, right? So they have noticed that you fully responded because that's where some litigation comes up. If you leave it open-ended and somebody thinks they're a more responsive document, they may continue to seek documents, okay? And this is the sticky one, right? Because remember, the Public Records Act is broadly construed, liberally construed, and it includes any written communication, any communication regarding the conduct of government, right? So if you're using your personal computers or tablets, if you're using your personal email, if you're using your personal cell phones, your personal phone numbers and text messages, and you're conducting government activity, those are subject to public records, right? So take care when you're using those devices that they may be subject to public records. There was about, Chuck may remember this, about a decade ago, there was massive litigation, I think with the city of Yelm over their mayor who refused to provide his cell phone, his personal cell phone, and I think a Yahoo account. And the city was fined millions of dollars and lost. And so be aware that when you're using your personal devices, that you may have public records on them. If you can avoid using your personal devices, do so. I believe that everybody here all the board members get a Board of Health email address.
Yeah, it'll be made available. It is something after this that you can opt out of, but you will have an email specifically with cdhg.wa.gov that will be part of archiving. That way it allows us to have anything. So, say in, what is the limit? 3 years? Mm-hmm. So say in 3 years, if you're not on the board anymore, we still have that as public record. So if someone does a public record request, for that time, we have access to all of that. We can get it out without bugging you. Otherwise, if you use your personal email, that will be subject to a public record request.
Yeah. So I encourage you, even though it can be annoying to have, 3 or 4 different emails, to use your official email for a business, because then the archiving happens automatically. You don't have to worry about it.
Okay, someone answered because I was just thinking, are we going to get a separate email account for this? But that includes all the alternates as well?
Yes.
Thank you.
Yeah.
Hey, question here from cyberspace. Hey, what could you all expand a little bit more on how how do we engage members of the public? So if we're approached by people, for example, on our personal emails, how do we then? It sounds to me like that conversation somehow needs to be diverted to the official email account. And then what are the guidelines around dealing with members of the public? Because these are not for appointed people; these are not constituents. And so I don't know. Do we have the same freedom to engage or responsibility to engage members of the public that the elected members do? Thank you.
Well, okay, there's a lot in that question. The first, I'll tackle the first one. If you get an inquiry from a member of the public on your personal email, I would immediately forward that to the official email. And if you respond to the member of the public, respond through your official email. And that way you have the record coming to the official email account. We can archive that, and that can be the record. And then any response would be through your official account. I was going to get to that. As a board member, it's a little, I don't know if there are any Star Trek fans. I'm going to get real dorky here. But as a board member, you are like the board, right? There is no individual action. You act as the board. You speak as a board. You are the board, and that's what Chuck was referring to when there's an 11-to-1 vote. That one dissenter, you made your case, you may not have won it, but you are the board. So going forward, that's the board. So take care if you get engaged by a member of the public, making a representation that something will happen. Now, you can certainly talk to members of the public to get input to bring things up to discuss before the board. And Chuck, I know you had some input on that.
The issue becomes, okay, now we have these lay people that everyone knows. I mean, you got neighbors, you got people that go to your church, you have people that know you, and it's like, well, I'm not going to call those elected officials. I don't know that. I'm going to call you. I'm going to email you. I'm going to get all my information through you. I have this and this and this that I want to do with the health district. Well, the one thing that, to touch on what Aaron said, is you as individual members of this board have absolutely zero power and authority, nothing. Individually, you can't do a thing. You need 6 buddies to do anything. You got to have 7 to make it happen, okay? So making commitments that can't be followed through on it's a tough one. I mean, the only commitment you can make is, I appreciate what you're saying, I'll take it to the board. When Aaron said about how somebody sends you the email and you respond by sending it to your own health district assigned email address, and then you launch into a discussion with them, I would encourage you to copy Holly on your discussion.
Yes.
Just like I copy my assistant, she's our assistant for the board, to make sure that she's keeping track of all of those emails. We don't have time as a district to go look at your email account all the time to make sure that everything's flowing appropriately. No, the work of the district of the board is going to be done at the board meetings. And I think those folks who have things that they think that you ought to do, I mean, you can bring them to the board, and we'll touch on this in a few minutes, but that's one of the positives out of this, having 6 lay people. We now have 6 more collective sites that we can get information from, so that, you know, we have 12 places now, plus the alternates, where we're getting input, you know, from all these different various places. But let's get the input in front of the board as a collective, so that you as a board can make the appropriate and proper decisions on things.
Yeah. And thanks, Chuck. That is a great piece of advice about copying Holly. And a secondary reason for that, bringing us back to the public records, is that email inquiry may have a hidden request for public records in it that you're not seeing, but your public records officer is a little bit more trained to see those things and may recognize that, oh, we actually need to respond to this as a public records request. So that's a really great piece of advice. So what happens with the request? Again, we've already talked about, you can't force a member of the public to request a record in a very specific way. We can certainly encourage it, and we do encourage it. We create an easy form for them to fill out. We make it easily accessible, makes Holly's life a lot easier, makes the attorney's life a lot easier. But it doesn't always happen that way. And if you get a request, even if it comes to your personal email or maybe comes in an odd way, we've got to consider it as a public records request. Again, the staff needs to process it in 5 business days, as we talked about, and that 5 business days could just be the thanks, we got it, we need some time. But that's a real drop dead deadline. We need to get it out in the 5 business days. Because there are penalties for non-compliance, and they can be very, very large. The penalty is per record. Now, a judge has discretion as to what that per record penalty is per day. It could be a penny a day per record. But if someone's requested 5,000 records, if it is $1 a day, that's $5,000 a day until you're in compliance. And often you don't get in compliance until you get out of the lawsuit. So you could have 2 years of non-compliance, and if you get $1 a day per record for 2 years, it can be devastating. And in addition, there are attorney's fees, and attorneys are very expensive, and the litigation over these can be complicated and expensive, which adds to the cost. There are folks out there that do make a living requesting public records and catching particularly small municipalities and special purpose districts up in technical violations. They make a living doing that. We've got at least 3 that we know about, that we've dealt with, that are just constantly engaged in this litigation. So it's a serious thing, and it can only be really changed through the legislature. So be aware. We don't want to incur any penalties. Even if they're small penalties, they're per record per day, and so a record can be each text message. If you are text messaging with Luke in one day, and you have 20 text messages back and forth, each text message could be a separate record, right? So those things can happen like that. Every single email is going to be a separate record, right? So they can add up very, very quickly. Okay. With that scary note, let's go to the practical.
This will be really quick. So just the practical things, and we just touched on it there a little bit, and I can't stress enough, it takes 7 board members to do anything. Individually, you're powerless, and you're putting the district out there and creating liability for them if you're making commitments that you can't follow through on. The commitment you can make is, I commit to you, constituent, that I will bring this to the board and see if we can do anything. That's the only commitment that you really can make. Keep the disagreements from getting too personal. I mean, there's going to be times where you disagree on things that, you know, the example of the 11-1 vote, you feel alone and stuff. I mean, always be courteous to the other board members, especially when you disagree with their viewpoints, you know. Avoiding surprises. And this, certain people are just wired this way. I call them smartest person in the room, okay? They want to come to a meeting and there's 12 people on the board and they want to raise their hand and say, look, and then poor Kate or Aaron or Chuck are there and the chair's looking at them, looking at us as legal counsel saying, what do we do? Because they didn't call anybody ahead of time and tell them what. They just wanted to come to the meeting, raise their hand and state it and throw it out there and create havoc. They don't know it sometimes, but I call it the smartest person in the room syndrome. I've seen it a number of times. I've been doing this for a long, long time. And it happens with council members, elected officials, every way. They could have easily called the staff ahead of time and said, hey, I want to do blah, and told them. And then we could have all had a conversation and said, okay, fine. When you do blah, we're going to tell you this, or this is how we'll deal with it, or we'll bring it up. Avoid the surprises. It's not fair to the other board members. It just impugns your credibility and your ability to continue on the board and for people to respect you. You know, I get it. There's going to be times where something comes up. Oh, I forgot about this. I want to ask about it. But it's the ambush surprise thing that's not fair to the rest of the board members. We all have busy lives. Everybody does. Get it on the agenda. Use the agenda to provide that notice to the board members instead of just raising your hand and saying blah. And I could fill in blah with a whole bunch of different things, and I'll save you from those stories for now. But understand you can't please everyone. You know, you're just not going to be able to. If we could please everyone, then we wouldn't need 12 people on the board. If we were going to please everyone, we would just have a dictatorship, the most efficient form of government ever. It's absolutely the most efficient form. Because one person, without having to discuss anything with anybody else, is the most efficient form of government. 12 people discussing things and doing the uncomfortable thing in the open public in front of the constituents is very uncomfortable sometimes, but it's through that process that we get the laws, policies, regulations that you want. Be really careful with the special interest groups that want to bend your ear to go in a direction that may not be the direction that the majority of the board wants. That doesn't mean don't listen to them. It just means be mindful of the fact that somebody that's talking to you about this may have only one way of looking at this, and they aren't looking at it from all the other perspectives, which is what we hope you as a board, as community members, not as a lawyer, but as community members, we want you to look at everything, you know, and be open to different perspectives. They said these resources, as we listed in the flyer, the Health District bylaws, look at those. The Open Public Meetings Act, look at that. Public Records Act. Anybody that hands you a record like Aaron was talking about, that has to go to Holly. That's not something you stick in your file that you later bring up to the board 15 days later, 10 business days after the 5-day limitation. Conflicts of financial interest, just take a look at it, 4223. If you're concerned about that at all, that's one of the areas where we insist that our clients give you direct access to us. Call Aaron, call Kate, call me, call us at our office, and we'll give you the advice. You don't need to run through anybody on that. If it's a conflict of financial interest, there's too much exposure for you personally as board members and for the district to make a mistake there. MRSC, the district pays to be a member of Municipal Research and Services Center, mrsc.org, and that's the 800 number. If you haven't been to their website, go to their website, take a look around. You know, you'll find, you know, many, many, many different things on public topics. Not a whole lot of things for health districts, but it's good to know the whole public process, because we don't we're not on an island here as a health district. We work with the counties, we work with the cities, we work with all the other special purpose districts in the area. So thank you. You know, when in doubt, ask, but thank you very much. I love doing this. I know Aaron, Kate, this is what we do. Really enjoy it. So thanks for having us, and we look forward to working with you as we move the district forward. Thanks. Any questions?
Yeah, actually, Open Meetings Act, is there one particular item that people make the biggest mistake with, that they didn't understand, they couldn't do?
Reply all on emails that are for informational purposes is a good one.
Okay.
Telling somebody what happened in an executive session, you'd be surprised how many times we get feedback from us like, how do you know that? You weren't there. Why are you calling me and telling me this? Because somebody in the executive session told somebody. And it's tough because there's 12 potential leaks when we have an executive session, you know, and that's you know, and not to point fingers, but you're never going to find who did it, and so that's probably the biggest area is leaking information after an executive session. And it's like, you know, what do you do? And I've seen other jurisdictions they admonish a person. Well, then you're all just highlighting the fact that that person did something they shouldn't have done, giving them another forum to do it. You know, I'm not a big fan of that. It's just play by the rules, or you know.
And to follow up, one of the consequences, particularly of sharing information in an executive session when it's to discuss litigation with your attorney, is we don't want to get into an argument with the other side about whether attorney-client privilege has been waived, and whether you have the authority to waive attorney-client privilege. You know, because the consequence if we lose that argument is the advice that we provide to the board could be disclosed during litigation, and that can be very, very harmful for the entity's position in litigation.
Great point. Yeah. Thanks. Thank you. Nobody's quit yet, so this is good. Well, thanks again. Oh yeah, you can remember. All right.
Thanks. So I feel like clapping after
All right. Okay. So we'll be working on